Welcome to Narrated C2C Journal, Editor's Introduction. Concerns over Canada's eroding free speech rights were relieved when the Justin Trudeau government's Online Harms Act died with the prorogation of Parliament. But this is no time to relax, writes Morrigan Geleynse. The authoritarian impulse to criminalize more and more types of speech still animates Canadian governments. As Geleynse explains, the threat stems from the rise of legal positivism, a doctrine that strips morality and higher authority from the time-honored link between human purpose, individual rights, and written law. The solution lies in rediscovering the wisdom and advice of St. Thomas Aquinas, one of history's greatest and most humane thinkers.
Aquinas' verdict. Natural law and legal positivism clash over free speech by Morrigan Geleynse. Quote, "We must love them both, those whose opinions we share and those whose opinions we reject, for both have labored in the search for truth and both have helped us in finding it." End quote. St. Thomas Aquinas. There is a disturbing willingness in Canada to suppress the fundamental right to freedom of speech, so long as the suppression is deemed to be in service of the common good. "We cannot tolerate anarchy on the internet," declared Justice Minister Arif Virani upon introducing the Justin Trudeau government's Bill C-63, the Online Harms Act. Internet sexual exploitation, especially of children, and hateful content are the forms of anarchy targeted by the Act. While a blitzkrieg upon the first would certainly be cheered, the criminalization of the second boils in controversy and threatens the rights and freedoms of all Canadians. Act or any other act of Parliament found to be motivated by hate to life imprisonment. While the bill died along with the prorogation of Parliament in December, this does not change the political willingness and apparent public support underlying it. And insofar as rights are recognized as inalienable, as the UN's Universal Declaration of Human Rights declares in its preamble, such a willingness marks a dangerous confusion of the meaning of justice. Like many laws, policies, and regulations pertaining to issues of liberty and free expression over the past few decades, Bill C-63 rests on a positivist conception. And as with other such measures, the damage wrought by hate speech censorship efforts goes far beyond immediate effects and leads to a disfigurement of human rights. Since gaining a foothold in the 1960s, the positivist view of rights has bestowed upon the state the authority to whittle, conjure, trample, suspend, and even, with satisfactory self-justifications, destroy them. Everything once taken for granted could be taken away, even inalienable rights, not least because we have allowed positivism to unburden us of the memory of why we considered them inalienable at all. The right to freedom of speech is threatened because we have forgotten the nature of human rights themselves. What to do? From the edges of the High Middle Ages, an understanding may be revealed in the bellow of a certain dumb ox. St. Thomas Aquinas and his explication of the natural law. Insofar as human rights are accepted as intrinsic and essential, Thomistic natural law provides the most reasonable framework by which to understand human rights. Elevating this philosophy in Canadian jurisprudence would create a reliable foundation upon which freedom of speech as a human right and hate speech as freedom of speech might be reconciled, the government's role in regulating these rights determined, and the violative trajectory of hate speech legislation brought back to earth.
Censorship crusades and legal positivism. How did we get here?
1965 marked the official beginning of Canada's crusade against hate speech, just 5 years after passage of the Federal Bill of Rights, and 17 years before the Charter of Rights and Freedoms. Guy Favreau, Minister of Justice in the minority Liberal government, commissioned a special committee on hate propaganda, whose findings led the government in 1970 to criminalize the promotion of genocide, public incitement of hatred, likely to disturb the peace, and the willful promotion of hatred, under newly added Sections 318, 319, and 320 of the Criminal Code of Canada. In its deliberations, the committee had faced a dilemma. Important though the combating of hate materials was believed to be, would criminalizing such expression infringe upon Canadians' right to free speech? The committee concluded freedom of speech was a qualified and not an absolute right. According to it, any speech failing to serve vital community interests, enhance the life of the speaker or the minds of others, or promote responsible discussion of the community interest could not be defended as a right. These findings represented positivism in action. Sweeping in their implications, they opened a can of worms that continue to plague us today. First off, it is impossible to speak of qualification without referring to some central standard or authority. Who determines when speech has failed to meet standards, and by what measures? Well, who was probably assumed to be the individual judge presiding over each hypothetical future case. A key concern is that determining what enhances the life of the speaker or the minds of those who hear him or her, and what constitutes responsible discussion, are all matters of abstract deliberation about which different judges may come to vastly differing conclusions. Any law consistently inconsistent in application must be doubted as a just law. Furthermore, the answer to the question, by what standard, is not fixed. It becomes by whatever standard governments and the courts determine. While the Universal Declaration of Human Rights, which Canada signed, proclaims human rights to be inalienable, speaking of rights in terms of qualified versus absolute implies the opposite, that such rights are legal constructs, the management of which rests with the state and its organs. One way to understand such thinking is as an application of legal positivism to human rights.
Still dangerous, the enduring threat to free speech, embodied in the Online Harms Act.
Introduced in February 2024, the Online Harms Act, OHA, combined stronger measures against sexual exploitation via the internet and heavier consequences for the publication of content that foments hatred. The fierce and sustained opposition to the latter measures prompted the Trudeau government last December to break the bill in two. Both halves were culled when the Governor-General prorogued Parliament that same month. Canadians should not assume, however, that the OHA's malign provisions can't be resurrected by a future Liberal government. The OHA embodied nearly every point of controversy and anti-hate measures proposed, enacted, and struck down in the nearly 6 decades since the Special Committee on Hate Propaganda. John Carpe, president of the Justice Centre for Constitutional Freedoms, which litigates on behalf of individual Canadians whose freedoms have been violated, wrote that it would take a dozen columns to properly address all of the threats to free expression that are contained in the Online Harms Act. From its pre-crime recognizances to raising the maximum sentence for hate-motivated crimes to life imprisonment, the expansion of what Bruce Pardy has dubbed the discretionary managerial state through the creation of a regulatory digital safety commission, and the failure to establish a workable definition of hate, the OHA was internationally flogged as an extremist and Orwellian attack on free speech. Under Bill C-63, you can be put away for life for a crime, whose legal existence hangs on the distinction between dislike and detest, wrote columnist Jane Stannis in The Spectator. Indeed, Part 2 of the OHA defines hatred as the emotion that involves detestation or vilification, and that is stronger than disdain or dislike. Upon this vague, subjective, and frighteningly broad basis for guilt, the OHA added Section 320.10111 to Canada's Criminal Code. Everyone who commits an offence under this Act, or any other Act of Parliament, if the commission of the offence is motivated by hatred based on prohibited grounds of discrimination, is guilty of an indictable offence and liable to imprisonment for life. Unlike laws that prohibit empirically provable actions such as theft or speeding, one that centers on an abstraction, in this case a person's internal feelings, requires subjective interpretation, which in turn becomes a recipe for judicial whimsy and inconsistency. A 2017 study on free speech and tolerance by the Cato Institute in Washington, D.C., found that conceptions of hate speech vary from person to person, often according to political affiliations. For example, 59% of progressives, what many Americans term liberals, regarded saying transgender people have a mental disorder to be hate speech, in contrast to just 17% of conservatives. One might argue that this is why we have experts, such as tribunal judges or the Supreme Court of Canada's justices, to settle such matters. The case of Bill Watcott undermines this argument. In 2005, the Saskatchewan Human Rights Commission brought Watcott before the province's Human Rights Tribunal due to 4 flyers about homosexuality that he'd distributed. The tribunal pronounced him guilty of disseminating hateful content on all 4 counts. The Saskatchewan Court of Appeal, however, found that none of the flyers constituted hate propaganda. The Supreme Court of Canada then found that 2 of the flyers expressed hatred and 2 did not. Which court was correct, and should the other judges be fired for incompetence? One might reply that the Supreme Court of Canada is the nation's final authority. Yet even it does not always reach consensus. When the High Court upheld the constitutionality of Section 13 of the Federal Human Rights Act, in 1990, Justice Beverly McLaughlin fell into the minority of the split verdict. Of defining hate, she wrote that it is a term vague and subjective, capable of extension should the interpreter be so inclined. Where does dislike leave off and hatred or contempt begin? McLaughlin further added, any expression likely to expose persons to hatred or contempt on a prohibited head of discrimination is caught, by the definition, regardless of whether the expression was intended or could be foreseen to have this effect. Seemingly good advice, but remember, McLaughlin was on the losing side. When judges of the highest caliber fail to agree on such matters, what authority determines who is correct? Consensus, even if it had been reached, is not infallible, and McLaughlin's perspective was vindicated 23 years later, when Section 13 was finally repealed. Was the decision to repeal it wrong, or were the majority of the Supreme Court judges in 1990? It should be noted that the OHA aimed to revive Section 13. Accordingly, while the OHA has died as a piece of legislation, the authoritarian urges it expressed have not been interred, and the threat these urges pose to Canadians lives on. The recurring nature of such bills raises the question, why are so many anti-hate laws unconstitutional? Answering that question requires asking an even more basic one. What is the nature of human rights? It is here that St. Thomas Aquinas can be brought to present-day Canada's aid.
Meet St. Thomas Aquinas.
Quote, he was a large and heavy and quiet boy and phenomenally silent, scarcely opened his mouth except to say suddenly to his schoolmaster in an explosive manner, "What is God?" End quote. G.K. Chesterton. Born in the Kingdom of Sicily in 1225, the future St. Thomas Aquinas was the youngest of 8 children of the Count of Aquino and the Countess of Tiano. At age 5, his family sent him to the Abbey of Monte Cassino to live and train as an oblate with the Benedictine monks. There, he was educated in scripture, theology, and philosophy, earning a reputation as a bright, promising, inquisitive mind. Political turmoil pulled him to the University of Naples in 1243, where he secretly joined the Dominican Order of Preachers, known for their poverty, uncloistered public engagement, and intellectual dedication. Appalled by this decision, his parents sent 2 of his brothers to kidnap him on the road to Paris, where the Dominicans had sent him. For over a year, they held him prisoner in a tower of their castle, trying to persuade him to change his mind. He would not budge, however, and his family at last relented. Following his release, the young Aquinas professed his religious vows and resumed his journey to the University of Paris. Aquinas was not only quiet, but, to put it kindly, rather stout. Inspired by these traits, his peers concocted an only half-ironic nickname, the Dumb Ox. His teacher, St. Albert the Great, predicted that despite the belittling epithet, Aquinas's bellowing in doctrine will one day resound throughout the world. Albert's words proved prophetic, and Aquinas earned the recognition of his era's scholars and popes. Until his death at 49, his life shone with a flaming intellect and a Christian devotion that established him as a giant of medieval scholasticism and a doctor of the Church and, following his passing, a canonized saint and father of what became known as Thomistic philosophy. In his writings, Aquinas strove to advance the unification of Aristotelian philosophy from ancient Greek times with Christian theology. Among the most important fruits of this, articulated in the Summa Theologica, 1265-73, was Thomistic natural law.
Natural law and the right to free speech.
Quote, the image of God always abides in the soul, whether this image be obsolete and clouded over as to amount to almost nothing, or whether it be obscured or disfigured, as is the case with sinners, or whether it be clear and beautiful, as is the case with the just. End quote. Summa Theologica. Natural law begins with the telos, the end purpose of a thing. Aristotle believed that all things have a telos, defining what they are and determining what is good for that thing. For instance, it is good for an acorn to grow into an oak tree. Ergo, that is an acorn's telos. And we know something is an acorn if it is within its nature to grow into an oak tree. Everything exists in such a way that its nature directs it toward its telos. In basic terms, Thomistic natural law is the universal body of inclinations, knowable through and prompted by reason, that compels human beings toward their telos. Being a Catholic, Aquinas believed the human telos was happiness through union with God. Truth, he wrote in the Summa Theologica, is to the greatest degree found in God, and in the Summa contra Gentiles, 1258-64, man's ultimate happiness consists in the contemplation of truth. Aquinas described 5 natural human inclinations: to do what is good and avoid evil, to preserve life, to marry and raise families, to pursue truth, and to participate in society. Even if one disagrees with Aquinas about humanity's telos, considering our rational, social, procreative, and moral nature, the 5 inclinations he set forth can still be regarded as essential aspects of fulfilling what it means to be human. Our human rights, such as the right to life, reflect these inclinations and are best understood within this framework of natural law. They are those needed to enable each individual to pursue and fulfill the inclinations that guide him or her toward their telos. For a thing to be a human right, that thing must be necessary, in its fullness, for a person to pursue that natural inclination. As Jacques Maritain, a Thomist philosopher and contributor to the Universal Declaration of Human Rights, wrote, as described by American philosopher, economist, and natural law theorist Samuel Gregg, rights were inviolable insofar as they protected the capacity of individuals to make choices freely in order to realize particular moral goods and virtues, central to human flourishing. Freedom of expression is a human right because it advances the pursuit of truth and knowledge through the exchange of ideas and enables participation in society. In the De Regno, 1265-1266, Aquinas wrote that man is a naturally social and political animal living in a multitude. Participating as such a being requires free expression and occurs through political discourse, scientific theorizing, religious practice, social and academic debate, arts and literature, and other contexts of communication. Without free speech, participation is crippled. Does hate speech deserve to be defended as free expression upon these grounds? Most would not believe it to be conducive to the pursuit of knowledge or truth, nor does it seem to improve society by its expression. Just the opposite. In spite of this, hate speech should not be banned as a category because many forms of odious speech do contribute indirectly to the pursuit of truth and enable participation in society. Odious speech is, of course, ugly speech. It reeks like a dead thing unearthed. Still, only by airing odious views can they be properly challenged. Let people gag at the rot rather than being fooled into perceiving yet another truth to power, martyr, and leaving flowers at his or her lionized grave. 19th century British philosopher John Stuart Mill stood powerfully against the censorship of unpopular beliefs in his famous essay On Liberty. If the opinion is right, those who can't hear the speech are deprived of the opportunity of exchanging error for truth. If wrong, they lose what is almost as great a benefit, the clearer perception and livelier impression of truth, produced by its collision with error. In the same era, Frederick Douglass, the American escaped slave-turned-philosopher and close friend to President Abraham Lincoln, echoed this point in his plea for freedom of speech in Boston. To suppress free speech, Douglass declared, is a double wrong. It violates the rights of the hearer as well as those of the speaker. Unpopular and ugly though someone's speech may be, it is only through the individual's ability to express personal beliefs that listeners have the chance to strengthen their grasp of the truth. Encountering contrary views compels closer examination of the listener's views, which may reveal their errors. Ideally, the speaker may be challenged, and if mistaken, have the chance to reform through similar examinations. In the case of someone expressing untruths, unkindness, or actual hatred, such a journey is impossible if that person is prevented from expressing them to begin with.
The limits of rights.
Quote, "Wherefore human laws do not forbid all vices, but only the more grievous vices, and chiefly those that are to the hurt of others, without the prohibition of which human society could not be maintained. Thus, human law prohibits murder, theft, and such like." End quote. Summa Theologica. This does not mean that natural law advocates for absolute freedom to speak without consequence. Not all speech or expression is protected as rights. Explicit threats of or incitement to violence are not considered rights. It is also true that certain types of non-permitted speech may be motivated by hatred, but this should be merely coincidental. The earlier point is that hate speech should not be prohibited as a category. Because human beings are also, and inevitably, sinful, or in more agreeably modern phrasing, because we act upon our capacity to make bad choices, some things considered vices must be permitted, namely those that do not damage a person's ability to pursue the human telos. Some forms of speech that may or may not be hateful are included in this. There is a notion that human rights describe categories of human behavior that would permit limitless action, and, accordingly, threaten to devour all social order if government did not establish boundaries. This is false. Actions which violate the rights of others would not exist as rights under natural law, even if government did not limit them. If the federal government declared tomorrow that we have absolute freedom of speech, that would not make threats of violence any more rightful than they are now. Such actions would continue to be violations of the rights of others. The logic of rights within Thomistic natural law is that we possess them because human beings were created in the image of God, imago Dei, and therefore carry infinite value. A non-Christian might assert we possess value by virtue of our humanity, wherever that might find its transcendent source or other external authority. Because imago Dei is a necessarily universal trait, everyone else must also have rights. The cliché is true. One's rights end where another's begin. The job of governments and courts should be to recognize the inherent boundaries, not manage, let alone continually shift them. All those years ago, Canada's Special Committee on Hate Propaganda was partially correct in saying that the category of action called freedom of speech was not an absolute. But it was incorrect in saying that the right to freedom of speech was not absolute.
The dumb ox in the kangaroo courts, a brief verdict.
Quote, "Now sometimes the things commanded by a superior are against God. Therefore superiors are not to be obeyed in all things." End quote. Summa Theologica. Human law, in Aquinas' view, is the body of laws written and enforced by human authorities to apply the natural law to the particular peoples and contexts of concern to the governing authorities. Any human law that contradicts the natural law is immoral. This directly opposes the positivist claim that a law gains legitimacy from the fact of it being written. As U.S. civil rights hero Martin Luther King Jr. wrote in his famous Letter from Birmingham Jail, one has not only a legal, but a moral responsibility to obey just laws. Conversely, one has a moral responsibility to disobey unjust laws. I would agree with St. Augustine that an unjust law is no law at all. The late Roman-era Augustine, whom King cited, was a great influence on Aquinas. Thomistic natural law renders hate speech censorship a violation of the right to freedom of speech. Positivism's first failure to meet natural law standards is its neglect of the necessity upon which true rights stand. This is also why positivism accepts several false rights, unnecessary to the pursuit of the telos, if not flatly contradicting it, as legitimate. One current example is the ostensible right to live free from discrimination. This concocted entitlement, beloved of human rights commissions, is not a true right because it is not needed to fulfill one's telos. Any discrimination that could threaten the human telos is already combated by the inherent rights to life, expression, conscience, religion, etc. Rights, if they are to be respected, must be anything but trivial. Even worse is the deeply disturbing assertion that there exists a right to die, another problem reflecting the grave consequences of positivism. This right did not even exist in Canada until 2016, which hints strongly at its overall legitimacy, since it was somehow overlooked both by the 1948 Universal Declaration of Human Rights and the preceding nearly 3,500 years of philosophy, theology, and Judeo-Christian scripture. In addition to its aforementioned dismissiveness towards the human telos, positivism's second failure to meet natural law standards is the outright damage it does to the human telos. For example, hate speech censorship, like what was expressed in the Online Harms Act, directly injures the pursuit of knowledge and truth, and the individual's participation in society. It drives bad ideas underground, where their holders are more likely to languish in self-martyrdom and their sympathizers to idolize them. It robs listeners of the opportunity to think critically about their own beliefs and to challenge the speaker's errors. Through vague and malleable definitions of hate, state-sanctioned censorship opens the door for trivial accusations and dire consequences, chilling free expression for fear of punishment. Its precedential force empowers government to further restrict freedom of speech and other rights. It places in the hands of the state an authority over which it has no claim, to manage human rights, an authority belonging entirely to the principles of the natural law.
Canada unmoored.
Quote, "Therefore, it is necessary to arrive at a prime mover, put in motion by no other." End quote. Summa Theologica. Aquinas' natural law, built upon the supremacy of God, is no foreigner in Canada. Our Latin motto, Amare usque ad mare, from sea to sea, is a direct reference to Psalm 72, verse 8, which reads, "He shall have dominion, also, from sea to sea, and from the river unto the ends of the earth." It is also no coincidence that the newly independent former colony of Canada was described as a dominion. Our national anthem prays, "God, keep our land glorious and free." The Canadian Charter of Rights and Freedoms begins with the acknowledgement, whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law. These principles have not been erased from Canada's defining documents, yet the nation's judicial and political systems have quietly nudged them under the rug. They are not divorced, though certainly estranged. Still, restoring natural law would not require Canada to embark on a strange, unnatural, or foreign project, but simply to reclaim her heritage. Natural law depends on, and is unreasonable without, belief in an intelligent creator of the universe, God in the Judeo-Christian sense. The decline of natural law in Canadian jurisprudence, therefore, cannot be separated from the rise of secularism and left-wing politics, particularly its more radical ambassadors. Perhaps not coincidentally, left-wing or progressive politicians and activists are usually also the most aggressive advocates for hate speech censorship laws. The conjunction makes sense. Those opposed to natural law are often of the more radical left-wing shades, because natural law stands in resolute contradiction to the left's faith in government as the nation's parent and ultimate source of all authority. God as supreme cannot coexist with the state as supreme. This is not to say that all those who advocate censoring hate speech hold the insidious goal of state supremacy in all things. But many surely do. And it is certainly the trajectory we are on, precedent by precedent. Freedom is far more fragile than many of us apparently realize. Canada needs natural law because our clear understanding of human rights depends upon its principles. Our progressive abandonment of it has made of us intellectual barbarians, as John Patrick, president of Augustine College, puts it. A barbarian, Patrick explains, is somebody who doesn't know his own cultural history. Though we may still enjoy the fruits of the natural law and Christian presuppositions about the world, the ability to maintain such a culture exceeds us in our ignorance. Without the natural law, we are no more able to preserve a proper understanding of rights than most people could rebuild a disassembled smartphone in spite of their daily use and enjoyment of it. There is something truly sacred about human rights, untouchable and distinct from the mere privileges granted by society. A right invoked should have the effect of an honest person's vow, a solemnity gathering around the weight of this invocation of eternal human worth in the eyes of the universe's very creator. Only the principles of natural law explain this weight. The crumbling of natural law in Canada has torn away the foundation for human rights. The Online Harms Act may be dead, but that does not change the fact that many believed it was a good idea, and enough were willing to impose it even on an unwilling nation. If we do not reclaim our heritage, it is inevitable that similar and possibly even worse proposals will come forth and perhaps prevail. Canada is unmoored. She has cast away the only meaningful conception of human rights ever to stride the world. Without this understanding, we will never preserve a reverence for life, the family unit, equality regardless of characteristics, or free speech and expression. We walk a darkening road, the medieval flame of St. Thomas Aquinas' natural law flickering behind us. By its illumination, we must turn back.
Morrigan Geleynse is a first-year English writing student at Redeemer University in Hamilton, Ontario. This article is an expanded adaptation of Ms. Geleynse's third prize-winning entry in the second annual Trottier Morgan Student Essay Contest. Don't forget to check out our website, c2cjournal.ca, for more stories. You can also sign up for our weekly newsletter and follow us on Facebook, Instagram, and